We're live.
Great. Good afternoon, everyone. Welcome to Senate Education. It is Tuesday, January 25th. We are going to return this afternoon to start by returning to S219, where we have Professor Derek Black joining us, who as well as Sue Siglowski. We're then going to shift to S139, an act relating to public school team mascots. And then at the end of our afternoon, we're going to have Elizabeth St. James in to talk about mandatory age of school attendance, as well as some language that I believe Senator Chittenden has been working with her on about kindergarten. So we'll have her in as well. But for now, Professor Black, welcome to Senate Education. Glad you're with us. I believe you are volunteering your time today on behalf of the Vermont NEA and the School Boards Association and the Principals Association and the Superintendents Association. Is that accurate?
They requested me to, but I would say I also see it being here on behalf of the state, just getting whatever information I can be of help to you.
Okay, terrific. Well, thank you for being with us. We know that I believe one email correspondence mentioned that you're under a tight schedule, so the floor is yours.
Well, I really appreciate that, Senator, and to the others there. It's really my pleasure an honor to have the opportunity to speak with you. I follow a lot of what goes on litigation-wise, and certainly was reading about your cases over the last year or so, and also filed an amicus brief in a case on behalf of the state of Maine, in a case that's pending. But just quickly about myself, I am the Ernest F. Hollings Chair in Constitutional Law and the Director of the Constitutional Law Center here at the University of South Carolina School of Law. But more broadly, I try to humbly say I'm one of the nation's leading experts on education law, and have written 30 plus scholarly articles and a few books, and also have an education law case book that is taught at numerous schools and law schools across the country. I'm not sure whether it's taught at Vermont or not, but it certainly makes its way around. So, my aim today is pretty narrow. I'm not going to comment on the bill. You guys know the ins and outs of the local issues far better than I do. Certainly would be happy to respond to questions to the extent I can. But what I really want to do is just give you a quick, brief primer on the legal issues floating around out there right now, just to make sure that you guys have the best up-to-date information. If there's any questions, I'm happy to answer them. There's sometimes some confusion, and I know some legislative bodies may not have counsel that focus on these things as closely. So I just wanted to be as helpful as I could. So I want to answer as quickly as possible 5 questions for you today. What exactly did Espinoza versus Montana prohibit? And that is the case involving a voucher program in the state of Montana from a couple of years ago. Want to then answer what does that case, or what did that case leave open or continue to allow? Then I also want to briefly raise a case called Fulton versus City of Philadelphia, which was decided this past year by the Supreme Court, dealing with another religious issue, not in the context of schools, but there are some important points there. And then to really narrow down on what issues are before the court and are not before the court in Carson versus Macon, which is the current case out of Maine. And then briefly talk about what options seem to be plainly still left on the table at state's discretion. So number one, what did Espinoza prohibit? Well, Espinoza prohibited a specific provision that barred religious schools from participating in a voucher program based upon their religious character. So there's sort of two sort of nuances there, right? It barred them completely from participation, and it barred them based upon one factor and one factor only, and that was the religious character of the schools. And the point there is that eligibility hinged solely upon whether you were or were not a religious school. And what the court is really concerned with there, or as I sort of articulate in some of my writings, is sort of this anti-targeting concept, right? That you ought not sort of target an institution simply because it's a religious institution for exclusion from a voucher program. If we're talking about a public education program, that's different. But in the context of a program open effectively to all, you cannot target someone based solely upon their religious status. At least in that context, there could be some nuance, but that's the basic concept. It's kind of like an anti-targeting concept. So what is left over from Espinoza that it didn't address or settle? Well, one of the things that they clearly sort of focus on, and Justice John Roberts points out at the end, is that Espinoza is not about whether funding private education is a good idea or a bad idea, whether vouchers are a good idea or a bad idea, that it remains up to the state to simply not fund private education if it chooses to, but if it chooses not to. But if it chooses to fund private education in the context of a voucher, and I think that's important, we'll come back to that context, but in the context of a voucher, then it cannot target or restrict participation based upon religious status. Now, the other issue floating around in Espinoza is what we call use restrictions. And so the court doesn't say, yes, you can have religious use restrictions. It doesn't say, no, you can't. It reserves that question, acknowledging that the use restriction had been important, at least in a previous case, Locke v. Davie out of Washington. And what the court had held in Locke v. Davie was that a state could choose to not fund a distinct category of instruction. So in Washington, they hadn't excluded anyone based upon their religious status. There were students who were going to religious schools, but what the state of Washington had said was, we're not going to fund instruction leading towards, or divinity instruction leading towards someone becoming a preacher, in effect, right? And so that they could carve out and say, we're not funding that type of instruction, but if you want to become an engineer at a religious school, we have no objection to that. If you want to study literature at a religious school. But so again, you have this distinction in Locke. They're not discriminating based upon status. What they're doing is limiting what can be done with state funds. And so that concept comes back up in Espinoza, which is, to reiterate, you can't discriminate based upon status, but there may be things that if the state doesn't want to fund them because of their religious nature, maybe the state can do that. That isn't religious discrimination. That's the state deciding what it wants to buy or what it doesn't want to buy, what it wants to fund or not. Now, the other case that came out this past summer, which intersects in all of this, is Fulton versus City of Philadelphia. That case involved an adoption agencies that assisted the City of Philadelphia, and because the Catholic adoption agency would not place families with LGBTQ, or wouldn't place children with LGBTQ families, Philadelphia had said that they could not participate in the city's general adoption program. And they said they couldn't because the city had a general anti-discrimination policy. And they said this amounts to discrimination that violates our policy. This case might sound like to one as being a blockbuster that sets up religion against anti-discrimination. It ended up being, quite frankly, a dud in many respects. And that's because there's this principle from older cases in which the court has held that if the state has a general policy and says we are going to create exemptions or exceptions for certain groups or individuals from that general policy, then religion must be granted an exception as well. That's not to say that religion must always be able to participate, but rather, if you are creating exceptions for some people, then you must also create them for religion. And so what the court found, and which made Fulton somewhat of a snoozer, was that the policy in Philadelphia already had an exemption to this, already had exemptions to the anti-discrimination policy. So if some people were getting exemptions, religion must get them as well. Now, although that basic holding is somewhat of a snoozer, as I keep calling it, there is what they didn't do is crucially important. There were a number of justices in Fulton versus the city of Philadelphia that had argued for overturning Oregon versus Smith. Oregon versus Smith was a case out of Oregon, of course, in which Justice Scalia, writing the majority opinion, had held that when it comes to what he called generally applicable rules, right? If you have a generally applicable rule, here we might say anti-discrimination, if you have a generally applicable rule, you don't get exemptions from that rule just because you're religious or just because it affects your religion in some way. An issue in that case was a general law prohibiting controlled substances and ingesting them. Someone said that they used them for religious reasons, and Justice Scalia said, doesn't matter why you use them. This is a generally applicable law. It doesn't target religion. And if the state or the federal government, for that matter, says, we don't want people using drugs and working for the state, they're free to do that. And the fact that it affects your religion is quite irrelevant. That's important because the court refused to overturn that principle that the state can maintain its general applicable rules. And so Fulton, from this past summer, had simply said, this isn't a generally applicable rule in Philadelphia because they're granting exceptions to some. So that's how those things interact. Now, to Carson, what's before the Supreme Court right now? The first thing I always like to emphasize, and I believe this is true of Vermont as well, but I could stand to be corrected, is that Carson versus Macon is not a voucher case. It is somewhat frustrating to me when people characterize or maybe mischaracterize it as such. I probably know their program better than yours, but it's not a voucher program, but rather it is a public education replacement program through which we have public-private partnerships, or maybe, at least in some districts, main district simply sends a child to another public school district. And that's important. The idea that it's not a voucher program, at least from Maine's perspective, is incredibly important because it's not that they are creating a general choice program for all the children in the state and then saying, well, we like some kids' choices, but we don't like other kids' choices, right? That is the problem that was at issue in Espinoza, right? It's a general choice program, but your choice can't be religion. And in Maine, it's not a general choice program. It only exists under certain circumstances and has certain academic requirements because, as I'm sure many of you know, they don't have a public high school in certain places. And that matters a lot. It matters a lot because the state gets to determine what its curriculum is. It may not get to determine what private schools do as a general principle, but if it's the state's curriculum or the state's program to serve its needs, it can determine what it wants done. So the question then, if we get to, that's the factual assessment of it. Now, the question is whether the way Maine has gone about that program amounts to a status restriction that looks a lot like Espinoza, or whether it is really a use restriction. Now, Maine has argued that it is a use restriction. Maine taking the position that we are simply restricting the use of public money from being used on religious activities, right? So it's not discriminating against all religious institutions. And in fact, it's the case in Maine that some religious institutions do participate in its program. And that, from the state's perspective, is really the ace in the hole. No one can accuse them, from their perspective, of discriminating based upon race. And therefore, it is therefore it is a use restriction. I can tell you in listening to the argument and also to the other side that the court began to focus heavily on the possibility that while Maine is calling it a use restriction, it in effect amounts to something like a status restriction. The idea being that the only people that they are focusing on for violations are religious entities, or that they are discriminating amongst religions, saying, well, if you're kind of religious, you can participate, but if you're really, really religious, you can't participate. So it seems what the court is focusing on there, and actually the concurrence in Vermont had focused on that in the Vermont case before the Second Circuit, on that distinction about discriminating within religious groups. So that's the key issue, and so
Professor Black, I'm sorry to interrupt. I just want to see Senator Lyons, did you have a question? We might as well. Okay, okay. Please continue, Professor.
Yeah, I'm almost sort of wrapping it up.
Yeah, take your time.
So there was a lot. It's not healthy to speculate about what a court will or won't do. You know, sometimes they often focus on a thing and oral argument, and then an opinion comes out differently. But what I am relatively confident about is the idea that what Maine is operating is not a voucher program, and therefore a different set of rules potentially would apply there. But if in operating this unique program, they were basically picking on religion because it is religious, then it looks like an Espinoza problem. So we will wait and see. I point that out, that distinction, if you follow it, because I think there is a possibility the court just doesn't answer this use restriction question again, right, which is incredibly important. But if what the court finds is that Maine has in fact targeted some religious groups rather than engaging in use restriction, then the court won't get to the use restriction question. All right, so what's probably most healthy is the last few comments about what remaining options do states have open at their discretion based upon the law as it stands now. Well, one of them is of course, the first question is to have or not have public funding for private education. If you choose to have what I would call a voucher program, then Espinoza clearly controls, and you can't just exclude someone based solely upon their religious status. If what you have is something that's not a voucher program, that looks like what I would call a contracting program, which is that the state is really engaging in a relationship between itself and some other private entity to do a job for the state, then the state gets to set the terms of that job. And the way I try to simplify that is to say that if Vermont or any other state said, we've decided that we want to buy oranges, and who sells oranges? And they say, company, Professor Black's company sells oranges, and they enter into that contract with me. Someone can't come along and say, yeah, but I've really got great apples. You should buy them from me too, or you should buy them from me instead. So that the state can set the terms of what it's buying. And that may not include religion. In fact, I would put to you that that if it's a close enough relationship, the state is precluded from buying religion, so to speak. And so the state does have the option of tightening up its relationship when it engages with private actors to make it clear that here's what we're buying, oranges, and we don't want apples. On the other hand, if the state were to say we're interested in buying fruit in general, and by fruit I'm sort of treating the apple as religion and the orange as non-religion, then it can't at that point go, oh, wait a minute, we don't want apples, right? Once you define broadly that we're just buying fruit, then you can't discriminate amongst that fruit based upon religion, for instance. And so the state still has, quite frankly, I believe, regardless of what happens in Carson, the state has enormous discretion to set the terms of its relationship because, of course, for quite a long time, you guys set what have set what the curriculum is, what the books are going to be used, what objective standards need to be met. So there's all of that stuff remains completely open. Very last point, and this goes back to potentially the problem in Maine. I don't personally believe it was a problem, but it could, if you looked at the facts in such a way, maybe it would be interpreted as a problem. And it's what you might call under-inclusivity, which is a state says it is worried about academic standards, for instance, or it's worried about the curriculum, but the only person's curriculum that is really double checking is the religious school's curriculum. And that's where it starts to look like you're picking on the religious schools because they're religious, not because they're failing to meet your academic standards. And so again, this folds back into my point that a state that's thinking seriously about replacing or providing a supplement to its public education program can define those programs in such a way that it may make it harder. That's not their purpose, but it may make it harder for religious groups to participate because maybe they're not willing to deliver the state's required education. But the state needs to make sure that all schools, regardless of their religious status, are meeting those standards, because otherwise it looks like the only people you're targeting, right, are religious schools. And that I think is what seems to have the court interested in Carson versus Macon, is the idea that they're targeting religion there. So with that, I'll stop. I'm happy to take questions if you have any. If not, I will turn my mic off.
Committee questions. Please, Senator Perchlik.
Yeah, thank you, Chair, and thank you, Mr. Black, for being here. I guess one of the questions that I have on this, whether this schools can discriminate, or whether we can say that they can't discriminate if they're taking state money. And what I heard you say, that if we're not targeting them, it's just for all schools can't discriminate, and we don't have a voucher program, so it's not that. But I wonder just how that jives in your mind, and maybe because it's not education law, you don't have an answer for it. But in the Supreme Court case on that wedding cake in Colorado case, where they said, yep, you can discriminate, even though there's a law that says you can't because it's against your religion. Why does that not hold for schools? Do you understand the question?
Yeah, that's a great question. I teach that case as well in my constitutional law class. So the court did not hold that the state of Colorado could not enforce an anti-discrimination mandate against all public businesses. But rather, when they looked into the evidence of that case, the court's conclusion was it looked like they were just picking on this religious group for this religious position, and that there was a lot of other stuff potentially going on in Colorado that they weren't attuned to. So the idea, that's a gross oversimplification of Masterpiece Cake Shop, but the idea that the court rests its decision on there is that, Colorado says that this is all about anti-discrimination, but it seems like the only people that they're picking on or the only people they're focused on for discrimination is LGBTQ and religion. So maybe to rephrase that, the court is kind of taking the position, it is taking the position in that case that the state says it's enforcing anti-discrimination, but what it's really doing is just using that as an excuse or pretext to focus on religion. And that's what I meant, was that there is no Supreme Court doctrine out there that says a state or the federal government cannot enforce anti-discrimination laws on religion. And we could go back quite a long ways. Some may have heard of Bob Jones, for instance, that a religious school here in South Carolina, in which they had taken the position on racial intermarriage, that it was against their religion. We've had religious institutions try to get exemptions from IRS tax provisions, the Civil Rights Act of 1964, things of this sort. To my knowledge, maybe someone could surprise you, there is no opinion in which the court's ever held you get an exemption from that. But the difference in those cases is, you look at Title VI, for instance, which prohibits racial discrimination. They're looking at racial discrimination in public and private schools and religious schools. They're not just picking on the religious schools. So I think Masterpiece Cake Shop is kind of special based upon its facts.
Okay, thank you.
Professor, Senator Lyons, please go ahead first.
So I have two questions. One, is there a way that we could get a summary of your testimony in writing? Because it's a lot for us to handle in a short period of time, even though it is extremely informative and really terrific.
Well, so let me be honest and candid with you. Trying to testify in between just finishing class and another program, I did not write something up. Depending on your time frame, I could get something together. I don't know how quickly you need that. And if I did, it's going to be sort of short and direct. It's not going to be an exposition of all of this, which makes academics uncomfortable. They want to slice it. But I'm willing to give you a hard, rough version of what I said today if you could give me a week or so to do it.
I would like that. I'm an academic and I would, so I'd appreciate the shorthand version. Whatever you have would be great. I do have kind of a question here. So if we have anti-discrimination policies in place for all of our public schools, and then we decide that we want to see anti-discrimination of one type or another for every school in the state, so independent schools, religious schools, all schools. If we only choose religious schools, then this does not pass muster. Then if we're going to treat one set of schools, we need to treat all sets of schools.
Yeah, that's a great question, which I think helps me sort of be even more crystal clear. If you had a general anti-discrimination program for all of the programs that are participating in your public program, right? Then you would need to look at, let's just use LGBTQ discrimination. You would need to look at and enforce LGBTQ discrimination just as seriously at the secular school as the religious school. And that's full stop, boom. And that's what creates the problem in Masterpiece Cake Shop, and also maybe in Macon, is the idea that the only people in America who you think engage in discrimination are religious groups, and so they're the only ones you're looking at, right? But if what you are doing is looking at everyone and making sure all children and all your programs are free of that discrimination, then the religious group is not in a position to claim that you are discriminating against them based upon who they are. What you're really doing is just making sure they comply with state standards.
Professor Black, the question about your comment intrigued me regarding how the state contracts for education, how the state contracts for other things. We're not a state that's contracting historically for students to, to have religious experiences, if you will. Maybe that's the way I could say it. That might make the most sense to me. So we want students to learn math, science, all sorts of history, languages, but to be in a school where they may be learning about not the history of religion, but the religion in the way I think we're all sort of thinking and talking about it is not what we want to contract for, I don't think. So is there a way for us to make that kind of contract null and void, not let that kind of contractual agreement happen?
Yeah, just so I'm clear, so is there a way for you to not have the state paying for the teaching of religion?
That's right.
Well, so this is where the hard work of legislatures comes into play. But it is basically the way I describe it in an article that I'm forthcoming. I was going to release it, but I'm waiting to get the final decision from Carson. But I think it sort of goes to the question of the state spending a little bit more time making decisions in advance. So for instance, you could say, right, here are the list of acceptable history books, and you could list 30 of them, right, that these history books conform to the state's general expectations, of history. And you probably already do that with your public schools, right? So as you begin talking about what we're buying, which is a private entity, which will teach history out of these books, you may very well be excluding religion without talking about religion, because you're saying this is what we are buying. And if you're not willing to teach this history to our kids, then we're not willing to give you money. So it's not a guarantee that religion wouldn't occur, but what I'm really articulating is, how do you fill the cup up, the cup being the school day, with the stuff that you expect children to be doing, and what you may find, or the books that they want to be used, whatever it may be, you may find then that there are certain religious institutions that's not the history they teach, right? And so either a kid would be ineligible to go to that school, or that school might not sign up with you. And that's that's what happened, to my understanding, in Maine to some extent, is because they haven't spelled out maybe as much as they may end up needing to after Carson, but what they clearly were doing was looking at what's being taught in the schools. And when they found stuff that was what they perceived to be inconsistent with what they expected to be taught, they said, no, right, this school can't participate. I think where they may get in trouble, they could get in trouble, is that that's kind of a decision that looks like it's being made on a case-by-case basis after the fact. I'm not saying that's what Maine has done. I think Maine did a very good job as best I could tell. But I think you're in a lot better position as a state if you spell out in advance, right, in legislation or through regulation, exactly what it is we expect of these institutions. And the ones who can't deliver on that are not eligible to participate. And I don't think you have to say a single word about religion when you do that.
So we could, for example, we don't have, this committee doesn't look at textbooks, doesn't have that kind of in-depth look, but we do have state standards. So we could match those state standards really up with our message of this is, again, what we expect. We don't mention religion in those state standards. We might mention the history of religion, but we don't mention the importance of knowing Christianity, Judaism, in terms of becoming, parts of those religions.
Mm-hmm. Yeah, that sounds correct to me. And you can also think about time, right? Now, there's always this balance between micromanagement, but you can also sort of require a certain amount of time be spent on a thing, right? Because I think that is something that has also come up in some charter school context, which is during the day, they're doing everything the state says that they should be doing and teaching and meeting those standards, but there may be additional things outside the school day for which the state is not paying, right? It's not on the state's dime or any of that stuff. And of course, just as it is in the public school, if the Christian Fellowship wants to have prayer before the prayer meeting and Bible reading before the school day starts or after, that's completely fine, but it doesn't happen as part of what the state is paying for and sponsoring. Yeah. So, yes, I think that.
Okay, Senator Chittenden.
Professor Black, this has been very helpful and also very validating with other testimony we've received from our attorney or our counsel, Jim Demaray, as well as Professor Teachout. So one question I have for you that I didn't hear you speak about in your testimony, and I'm wondering if you have any commentary to offer. Also, I just want to note, I really appreciate the Oregon versus Smith case. That's the first time I recall jotting that down, but the general applicability rule is quite enlightening to overlay with what we've already heard. But what's also come up in our discussions has to do with the Guadalupe case and the ministerial exception. So if we were to set the standards that the fruit providers, those that want to sell the state oranges or fruit in general, that they also abide by hiring practices that are not discriminatory, does that intersect with the Guadalupe case in a way of circumventing it? Again, if it's not targeting religion, but just a standard in hiring practices for all that want to sell as fruit, has that come up in your discussions?
That Guadalupe is not relevant to the question of a state-run program, right? Because Guadalupe is talking about a general law that applies to everyone out there in employment from which religion can't escape its reach, right? Which is everyone's regulated no matter what. Whereas in the voucher context, or more specifically in a context in which the state is engaging in what I at least call rough-handedly contracting, the religious group doesn't have to participate, right? And so Guadalupe doesn't come into that scenario because the state is not forcing a particular school to hire or not hire someone. They can do whatever they want to. It's just the rules change if they voluntarily participate in the public program. So I don't perceive Guadalupe as presenting a problem.
Senator Perchlik.
Thank you. I guess it's not a similar question, but it's a question. I don't know if you looked at the bill at all, but one of the things we're contemplating in the bill of doing is requiring a kind of certification from the schools that, basically that they're going to comply with discrimination laws and work to enforce them. But then we go on to say this doesn't apply to public schools. And so I wondered, I don't want to ask you to give us your legal opinion, but I'm asking you to give us your legal opinion on whether that's problematic, that we would be targeting just the religious schools and say religious schools have to give the certification, but public schools don't.
Great question.
Well, let me, make sure I'm following it correctly. When you say religious schools, you really mean all private schools. Maybe most of them are religious, but when you say you're not just applying anti-discrimination to religious schools, it's to private schools. So the distinction is private versus public schools, not public versus religion. Am I correct on that?
Yeah, we don't use the word private, but yeah, basically that is true. We're just saying that the requirement to give a certification doesn't apply to the public schools. So.
Sure. I don't see that as being a problem because, to be quite honest, you have no power to exempt your schools from your public schools from anti-discrimination. It already applies. So it's not as though you're applying a standard to private schools that doesn't exist in the public schools. The Civil Rights Act of 1964, Title IX of the Education Amendments of 1974, and a number of others that they all already apply, which did jog my memory to something that's in my article that'll be forthcoming this summer, which is, I think one of the things some states may not, I'm not saying Vermont, but some states may not be sufficiently attuned to, is that it's possible that they are violating the law by not applying anti-discrimination. And what I mean by that is, if, depending on how you structure a program, so let's say whether it's Maine's or Vermont's, if it is sufficiently intertwined with your overall state education program, then Title VI and Title IX would apply to all of the state's education programs, regardless of what you might think. And let me give you an example, just so we're crystal clear. There was the original case on this was versus the University of Chicago, a private institution that was receiving federal funds, and the only entity at Chicago, or the allegation, and I'm sorry, it wasn't Chicago was the first case, and there was a community college, but the only entity at this private, or maybe it was even public, but this particular university that was receiving federal dollars was the financial aid office. And so the defense in that case was, sure, we have to comply with anti-discrimination in the financial aid office, but our swim team, let's just say, doesn't receive any federal dollars and doesn't have anyone, on federal dollars, that doesn't apply there. And the court initially was receptive to that, but Congress went back in Title IX and redefined it and said, one receipt of $1 makes the entire entity a covered entity. So it doesn't matter what parts get or don't get money. How does that relate to vouchers and charters, et cetera? I'll just take a specific state. West Virginia is, for rough terms, has structured a voucher program that is controlled, administered, and the dollars flow through the State Department of Education. And it is my professional opinion that if what we really have is a covered entity, the Department of Education, administering and overseeing these private schools, but not making them comply with the same standards the Department of Education is applying with, it arguably is a violation of Title VI. That's a little bit different than, that's a lot different than, for instance, Montana, where they're just giving out tax credits, right? The Department of Education, no education program is actually involved in the tax credit program for private schools in Maine. So that's just something else to be aware of, that maybe not you, but some states might find themselves being sued for their failure to enforce anti-discrimination in programs that are sufficiently interlinked with their state education programs.
Other questions? Yes, Senator Chittenden.
I guess since we have you and you're a very busy person, I just want to pick up on Senator Perchlik's question there. And in the bill, as he currently understands it, we are not requiring public schools to fit this to complete this certification. But I feel like in your testimony, and what I've heard elsewhere, is it would be more defensible, according to current case law, that if we did in fact require it. Do you have any, or make clear that they're required to do in the absence of any federal exemptions from these anti-discriminatory rules? Do you have any cautions on how we would frame the language around the public schools, not exemption, but absence of requirement?
I mean, I hadn't really thought about this particular problem that you're raising. It strikes me, whether you do it or don't do it doesn't matter, because again, all your public schools are in receipt of federal funds. They're all state actors as well. So the United States Constitution and all the federal civil rights acts already apply to them. And whether they've signed or certified or not, if there's any discrimination that's occurring in one of those schools, a lawsuit could be filed tomorrow, regardless of whether you extend anything to it. So I think the one argument against that certification idea for a public school, and again, I don't think it really matters that much, is busy work. I'll have to say one of the things that's concerned me, I'm not saying that document would be busy work per se, but public schools and our teachers, as you guys know very well, are sort of struggling just in sort of triage mode. They had a lot of busy work before before COVID, but we've got real problems in front of us. And I think adding more paperwork is not a good idea if it's the case that they're already subject to these anti-discrimination principles. But again, obviously it's in your discretion as to whether you impose such a thing.
It's very helpful. Very helpful. It's great testimony. Any final comments from you, Professor Black, at this point?
Just one sort of final one. I mean, I've tried my best to sort of give you guys my sense of the legal lines. The final comment I would make, and this is really based upon the brief that I filed in Macon, is that if what the state is doing is hiring a public education replacement, right, which is to say, we're unable to deliver our normal public education program in a particular jurisdiction, and therefore we're going to contract or do some sort of public-private partnerships. I think one thing to always remember, and we really emphasize this, a number of people emphasize, is that Maine has a state constitutional obligation to deliver public education. Vermont has that as well and has gone through litigation over the years with that. And so if what you are doing is trying to hire services to discharge your state constitutional duty, well, the state constitutional education program has to be non-religion, right? No state can say, you know what, we're changing our public education motto and we're going to start, inculcating religion in, public school elementary #1. And I think that's just an important frame to understand. Again, I don't know your program perfectly, but if what a state is doing is discharging its constitutional responsibility to serve all students with a public education, then those same values that are part of the public education system need to be protected when you hire some private entity to help you. Because what you cannot do in Maine or Vermont or anywhere else is get rid of that state constitutional duty to deliver an adequate and equal public education. If students don't want that education and they're just pursuing it for whatever reasons, that's a different question. But if what Vermont or Maine is doing is discharging its public duty, then there are values that must accompany that public duty. And there are cases filed right now challenging voucher programs as being inconsistent with or interfering with the discharge of that state constitutional duty. There's a case pending in Ohio, West Virginia, Kentucky, probably another, but those are the ones that come to my mind right now at the moment that are basically raising that exact same issue in Tennessee as well.
So,
Please, Senator Hooker. Yes.
thank you, Professor Black. Can I just clarify then, voucher as opposed to paying tuition? So a voucher is given to a family, they can use it wherever they want. Is that the difference that I'm hearing here?
That's a great question, and this was a question that was really an issue in the oral arguments in Carson versus Maine, which is this a choice program? And you're like, well, what's a choice program? What's a voucher program? The simplest way of stating, in my mind, what a choice or a voucher program is a state saying, you know what, we want to kind of just help you afford the cost of your private education, right? We don't care where you go, what you like that's your business. We're just kind of like, we all file our tax returns and we get credits back for certain things. So instead of a tax, and IRS doesn't ask you, did you buy, your weather stripping at Lowe's or Home Depot? They just say, did you buy weather stripping this year? If so, you get a tax credit. And a voucher programs typically look like that too. There's almost no sort of regulation or restriction on them. It's just sort of like, hey, for people who don't want to be part of the public system, have at it. We're going to give you some money. I'll say up front, if it's not apparent. I mean, I don't think those are particularly good policy. I'll say that as a general principle, but they are understandable policy that some states might want to pursue. But if what the state is doing, which is distinct from that, is saying, no, we actually have an interest in children learning A, B, and C. We would normally do that in a public school, or we're trying to build a new public school there, but we can't get it built yet, or there's not a sufficient population. So we can't deliver our normal, right, sort of program in your community. Then that's not a voucher program, right? And that is, at least as Maine, I think, using good word, that's a public education equivalent program. And at least that's how they articulate it as being. And I think what makes that more obvious is that not every student in the state is eligible to get a public education equivalent. You only get that option when the state is unable to discharge its regular duty. And even then, right, the local school district, at least in Maine, is not required to allow you to take the option of a private school. They could say, you know what, in school district B, we decided we're just going to get in a relationship with our next door neighbor school district. So there will be no private education. So that's not a voucher at all, right? That is the state working out a unique situation to discharge its public education duty to its students. Maybe a very thin distinction if you're not in that policy world, but at least in my world, it's an enormous distinction.
Mr. Black, again, thank you for being with us. Incredibly helpful. Grateful for your time. Be great if you get some of those articles out sooner rather than later. They might help us. And if there's anything else you think we should read, though, between now and our decision making, which is coming up, please feel free to forward anything to us.
Well, thank you for the opportunity, and I appreciate you taking it so seriously. So I appreciate that. Thank you.
Yeah, thank you. Ms. Siglowski, see you have chosen the short straw. None of your colleagues are with you. They wouldn't even show up.
They are not here, but they're all behind what I'm the message that I'm delivering.
They're watching from the comforts of their home.
I'm Sue Siglowski. I'm the Executive Director of the Vermont School Boards Association, and I'm here today delivering some joint testimony from the Vermont School Boards Association, the Vermont NEA, Vermont Superintendents Association, and the Vermont Principals Association. And all four of our associations would like to thank you for the opportunity to provide joint testimony on S219, a bill addressing the use of public funds for tuition and in dual enrollment programs. To address the issues raised in this bill appropriately, we believe it is prudent to wait until the United States Supreme Court issues an opinion in Carson v. Macon. We've spoken with national experts, including Professor Derek Black, who you just heard from, who indicated that there are several variations on how the court could rule in that case. And responding in a narrow fashion in advance of the Supreme Court's decision in Carson, we think is ill-advised because the response may not coordinate well with the decision that gets issued. The court is expected to issue a decision in late spring or early summer of 2022. We appreciate and share the committee's concerns that public dollars should not support discrimination in any way. Independent schools that receive public tuition dollars should be required to comply with all of the same federal and state anti-discrimination laws that are applicable to public schools. In order to address these concerns fully and appropriately, we ask that the committee wait until the next legislative session to advance a bill on this topic. And that concludes my testimony. Thank you.
So, Ms. Siglowski, at one point, I know that there were conversations about perhaps all of you moving in a different direction, which has been sort of out there in the public a little bit, where it seemed to you that it made sense to shut down our smaller schools, if you will, stop the tuitioning and take a transition period where our academies became public schools. Are you saying now that that is not a position that you're interested in?
What I'm saying is that we believe that it's appropriate to wait until the decision is issued in Carson v. Macon before tackling this issue.
So how would the decision, just help me understand, how would what Mr. Black just laid out, Professor Black just laid out in terms of the possibilities, how is waiting at this point? Why does it really make sense? It sounds to me like we have additional information, some good information on how we might move forward. It seems to me that it's before us right now. One of the lessons I remember learning from Speaker Obahowski is don't anticipate how decisions are going to be made. Don't anticipate, even Professor Black saying, sitting and wondering how things are going to happen. These things don't usually get us anywhere. So why does waiting now, when we have all of this information, make the most sense to you?
I think it does make sense to wait because we will have more information once that decision is issued.
So that's key. What information might we have that would influence, that would change what we do next year?
So I think we're going to know, one of the things that Professor Black talked about was whether or not the court gets into the use distinction in that decision. That's something that we're going to know once the decision is issued. And there are, several ways that the court could go. One thing that could happen is that there's an issue of standing in that case. The court could dismiss it for lack of standing there. And then if it doesn't, there's 3 general areas that the court could go in. And it can influence the way that the options that you have for addressing this. So we think that it's best to wait until after we have all of that information, so that the issues can be addressed fully and thoroughly.
So do you feel our LGBTQ students are protected right now? I'm sorry, did you hear that?
Yes,
Okay.
I heard you. So
Okay,
I think the response that I would give you, Senator Campion, is that it's our position that public dollars should not support discrimination in any way. And we want to make sure that the solution to any discrimination possibly in the future or that may be occurring currently is done in the best way possible. And we think that the best way to do that is with the best available information that we can get. And that it's important to understand what the Carson v. Macon case decision is before proceeding.
So how will the Carson v. Macon case influence the anti-LGBTQ, the anti-discrimination pieces? Why wouldn't we put something in place now to send a message to the community, to Vermonters?
You certainly could begin to tackle that now if that is the direction that the committee decides that it wants to go in.
But you would not support it?
No, I'm not saying we wouldn't. We think you should wait. If you decide to go in that direction, we certainly would, participate in the conversation. But we also think that rather than addressing discrimination in isolation, it should be done as part of a broader inquiry by the state about its contractual relationship with tuition schools, and really take a look at ensuring that the tuition program as a whole meets the state's obligation to provide education under the Vermont Constitution. The bottom line is that there are requirements the state ought to be imposing equally on any schools that it funds. So short message is we would like to see you wait. But if you decide that you're going to go forward with the anti-discrimination piece, we'd be happy to be invited back.
But you wouldn't support it.
No, I didn't say that we wouldn't support it. What I've said repeatedly is that we do not support public dollars. Where our position is that public dollars should not support discrimination in any way.
Questions for Ms. Siglowski? Okay, Senator Hooker, please.
Thank you. And thank you, Sue, for being here again. In the paper, in the Herald this morning, there was an article about school budgets and stuff. And one of the lines that caught my attention was that IRA is tuitioning students to MSJ, Catholic school. I'm curious to know how many districts are allowing that.
That's a great question. I don't have the figures off the top of my head, but I could certainly try to find that out for you, Senator Hooker.
Thank you.
You're welcome.
Yeah, Senator Perswick.
Yeah, thank you, Chair. Ms. Siglowski, do you think the position would change, either of your organization or your sister organizations that you're speaking for today, if we were to point to discrimination that was happening today? If there was an example of approved independent school that was discriminating and they were giving the reason that it was for religious reasons, would you feel differently about the need to wait?
Are you referring to an approved independent school that's receiving public funds?
Yes.
So I'm just going to restate our basic position that we believe it is the best approach is to wait, because we think we'll have more guidance from the decision, and it is not very far away. We expect it to be issued probably in June or July. And
we're not back in session until January, which makes it well over perhaps a year where you could have LGBT, young people discriminated against. I have to say, I'm somewhat surprised that those representing our teachers, superintendents, principals, and school board members would really want us to wait on this and wouldn't support this kind of action now, when it could. Sure, a decision comes back in June. We're in session in January. It makes its all way. We're talking well over a year. You would think, I have to say, I'm quite surprised.
Well, I think I've stated several times that we believe public dollars should not support discrimination in any way. And we want to make sure that that there's a good solution to this. I think one of the issues that we have here is that there are several components to this bill, and for the reasons of some parts of the bill, it's really important to wait. And so I'm speaking to the bill as a whole when I say that we think it's important to wait, not specifically the anti-discrimination provision. And if that's something that the committee wants to move forward with, then we're happy to come back in and talk about that.
Senator Chinden.
So that's effectively where I was going to go with this. So thank you, Sue. And I got to say, your testimony is always really compelling. And I would just say this: if this committee isn't inclined to wait because we share the stated point of view that we don't want dollars to go to schools that discriminate, I would be more interested to hear where you and your organization stand on this bill. We hear that you want us to wait, but I haven't heard that you're opposed to the bill and the language that is in it. So I personally think that this is important for us to lay down our values in light of the court cases that have been put forward. So I'm disinclined to wait, but I guess I am new at this, and I would want to hear what concerns there are about acting before this court Macon decision comes out. I'm not seeing the caution in your testimony as to what the risks are by acting before it comes out. So I'm more inclined to continue on our track, and I'd love to hear more of your organization's thoughts on the specific language before us, maybe at another time, of course.
Yeah, we'd be happy to come back another time if you'd like us to.
Can you just humor us right now? Just say just respond to the bill right now concerns.
I'm not really at liberty right now to do that and get into the specifics on the bill. But as I said, we would all be happy to come back in at another time.
The email that I received said this was a sort of a one-time visit. Of course, I responded by saying, really, there's no such thing as a one-time visit. And that we may have you all back. But at this point, no comments about the bill itself. That's accurate.
I think that I'd just like to end by reiterating that we would like to see robust protections in place, anti-discrimination protections in place for all schools that receive public funding. That is very important to all of our organizations.
So, and just to clarify, now or in a year and a half?
If the committee would like to move forward on
No,
it.
no, I'm sorry.
Now.
What would all of you like to see, now or in a year and a half? It's a fair question. You're representing our children and our teachers.
We would like to see that happen as soon as possible. And it's going to take, it's not an issue that can be addressed quickly. There are a lot of considerations that you need to take there's a lot that you need to take under consideration.
Okay.
So we want it addressed as soon as possible. That's what I can say.
Okay, that's helpful. Committee, additional questions for Ms. Siglowski? Ms. Siglowski, any final comments for us at this point? We will have you back in. We're going to, of course, talk with a little bit more with our Ledge Council and Professor Teachout. But I suspect on Friday, when we pick this up again, we'll have you and some of your colleagues in to continue the conversation.
We look forward to it. Thank you very much.
Great. Thank you. So committee, let's, we have Jay Nichols coming in at 2:45. So let's just take a little break and